Bad Empanada is a guy on the internet. Bad Empanada, real name George Ginitis, which just does really sound like something that they sell a cream to cure. Are you suffering from topical George Ginitis or intestinal George Ginitis? Well, new Savitra has got the cure for you. Side effects. You're stupid as fuck now, son. But he posted this. Bad Empanada is a guy in the internet. Somebody's like, you got to introduce him more often because people don't know about him. And I don't know if they were being facetious or not. Bad Empanada is an a Greek-Australian guy who moved to Argentina to basically do like lefty LARP tourism and take advantage of their really open immigration policies and the fact that they got fucking really good bennies. They got great benefits. As a matter of fact, the reason that they have Javier Milei as president right now is because fucking Bad Empanada went up there and sucked up all the benefits that belong to the native Argentinians. I drink your milkshake. I drink it up. But he's guilty of one of the things that I fucking hate most about internet politics commentators, and that is just getting really outside of where your range is talking about politics in another country. You know what I mean? You probably don't. Bad Empanada recently posted, I guess I'll read this in a second, about talking about the fair use precedent set by H3H3 Productions, and I guess he did what he thought was research to debunk that H3H3 ever did anything good for the internet at all. Because he is, and I really can't hammer this home enough, a foreign honky. He doesn't know what he's fucking talking about, which is kind of god tier. Because I decided to look into the case, and I found out that, as per usual, that this seems to be a thing that's happening more and more often with him, as I guess he's like scraping the barrel for H3H3 content, is he's fucking fucked up again. I think it's going to be sometime this week. I'm going to be watching Willie Mack Show's fucking cuck video. Willie Mack Show's, I think at this point, he's like literally connected to Ethan Klein's dick surgically. And Ethan Klein is actually going to have him removed, or he's going to die of dehydration, because Willie Mack Show is sucking it dry, but he gets to keep bringing up Bad Empanada stuff because Bad Empanada keeps fucking up. The criticism is fine, but then he just gets like basic facts wrong and kind of puts himself in a position where he looks like a fucking idiot, and it's easy to let him talk for a while because he's just wrong. One of the things is with Giardia, the CPS call against the Kleins was based because the Kleins were talking about openly that they have fucking Giardia, right? I mean, do I have the clip here for that? No, we're not going to bother with those clips. We'll do that again. If somebody wants to fucking call me on that one, we'll bust the clips out for that. A million people have done it. Ethan joked that his kids have Giardia. Now, when Bad Empanada was talking about it, he's like a relatively unheard of to man, uncommon to man thing. Because he fucked up that talking point, Giardia is extremely common. It's all over the place because it's like the flu, right? It's still dangerous, and there's a lot of issues that come with it, but it is common. Why? Because it spreads really fucking fast. If there's an outbreak of it, it's everywhere all of a sudden because it really wants to spread. It is a infectious amoeba. It's not a bacteria. It's not a virus. It is a parasite. A whole organism with little wiggly, feely bits that creeps and crawls and lays shit in your stomach. The reason why the CPS call is warranted isn't because Giardia is unsurvivable. It will kill people that are weaker, as all illnesses can statistically do. The problem with Giardia is, especially around kids, is it spreads very, very fast. The Giardia parasite has a life cycle where basically if you're unclean and you don't wash your hands very often, which is very common apparently amongst the wealthy of LA, or children in general, they turn into cysts, right? And these cyst-like egg sacs, or whatever the fuck they are, go and they'll get on your hands, and they are impossible to like necessarily, if I remember correctly, destroy. It's very difficult. But soap will wrap around them, and then they'll go into the drain, and then they won't be a problem anymore, right, for you. If you don't have really good hygiene, they'll get on like doorknobs and stuff, and then you can have a massive outbreak, which, you know, it's not going to kill every kid at your school, but every kid at your school is going to get potentially chronic intestinal inflammation issues, and they're going to be shitting their fucking brains out for weeks and be miserable. It's not good to get people sick. So if you say that you have Giardia, it's a mandatory report. This is everywhere. It is a mandatory reporting situation for anybody that is a mandatory reporter. Okay? And anyone, if you are a parent and you believe that your fucking somebody around you has Giardia and is bringing their kids around you, you should report them to CPS and any other health professionals that you need to in order to ensure that they don't have it and they're not spreading it around, because it will cause outbreaks. Serious fucking outbreaks. That's what happens. That's why it's common, is because there's never just one. If there's a Giardia outbreak, it's fucking thousands of people all at once. This is why it usually happens in third world countries, so to say, and basically any place that has broken, open sewage lines or standing water, is because that's the best vector for them to spread. And then if you don't have the ability to clean your hands and make the wash what you clean with go away, then you can get reinfected or infect other people, okay? So that's the point of Giardia. The CPS call was legit, and the CPS call was based. Adding on to that you think the parent, the client should just like lose their kids or something. I don't think they should lose their kids, but they should be embarrassed. They should feel humiliated. Don't say that your kid was eating shit on the internet is a really normal thing to say. And kind of like, he's been leaning into all this sort of stuff, whatever. Some of it's good content, but now it's kind of like extending itself. And so we're transitioning from a place where Hassan was the h3h3 bad guy, which was okay because they're at the same level, and Hassan can interact with h3h3 and Ethan in a ways that some Argentinian fucking honky can't. Say that better. Greek Cypriot Marxist. The perfect organism, unconcerned with hatred or weakness or mercy. I admire its purity. He's really overselling his positions, is where I'm getting to. And it is turning into a point where even fucking Ethan Klein is apparently like tweeted or something. I feel like Empanada is working. Like, if Empanada is not working for Israel to like keep the genocide ongoing, I don't know what the fuck he's doing. And it really is the case. He has fucked up everything. Like, it's kind of nuts how incompetent he is, to the point where it's like, I'm like, I don't know if the guy's a glowy or not. Because the second any sort of attention was paid to him and he became like the main player instead of Hassan, who's got other stuff to talk about now, he's fucking horrible at it. He's a terrible main guy to have. He's fucking dog shit. I think I said this before. He's probably the reason why, Stalin has a fucking airbrush, and he's not going to be Stalin. God damn it. No fucking way. So this guy just kind of fucking tries to go in and hammer down on stuff, but he's repeatedly off. He's incorrect, he's wrong, or he like leans into it and kind of revels in the cruelty. But at a certain point, like, if you're trying to make your side look good, you have to have someone on your side who looks good. Because if you're just reveling in performative cruelty, the only people that you are going to attract are performatively cruel people, because everyone else is going to go cringe or I'm a nice person, right? You gotta have something else there, and there's not much available because the information is I really can't hammer this home enough, very often bad or slightly inaccurate or off, or it's made out of his conjecture or his inability to understand the situations at play. Like, he's not American, but he talks about America, which is not a great place to be in if you're not someone who like went to college here, or you're not like a foreign policy expert. I really have to hammer this out. You foreigners don't sound like you know what you're talking about when you talk about America. I think it's cute that you watch whatever your Australia Broadcasting Corporation, or you read your Guardian newspaper, and then you're like, I've heard the name Marjorie Taylor Greene a few times or two. You're from Kentucky. Andy Bache here is your governor, I believe. It's like, okay, you're adorable. Look at you. Did you get a fucking... Did you get any civics education in America? Do you know how our fucking systems work? Because, like, the subtleties are kind of like what the heart of politics really is. No, I just like it for the personalities in general. I really appreciate making fun of people with a different accent. I'm actually still just quite colonial in my dispositions. And this is kind of what you all sound like. Even if you're from non-Anglosphere countries, it's like... Even when you're really mad at me about stuff my country actually did, some of you are so off base in your criticisms, or you say inaccurate shit because you feel like you're justified in it, that you sound like stupid children. And that's not a good place to be in if you want people to have faith in what you're saying and change the way that they think in order to give you what you want in this world, right? So if we have like a victory over somebody, like an Ethan Klein, like, hey, Ethan Klein's dumb. Okay, and he kind of sucks. All right, sure. But what about you guys? And then the best we have is fucking Bad Empanada. We're fucking up, right? Because it does feel like he pulled out, and now I'm not seeing anything else in that sphere but him. And he's fucking dog shit at this. He couldn't fucking come after me without accidentally partnering with necrophiles. This is how easy it is to mislead the guy. So I don't know where he gets his information. Because first, I really have to hit this home. He's not American, so I don't know if he's reading newspapers or whatever, because if it's like, well, you can just trust the mainstream media and stuff, like, what? Are you just fucking reading Reddit and then you think you know about America? Like, that's not good. Because, check fucking, shout out Flesh Simulator, and his thing on, did you know that like 75% of the fucking posts on Reddit come from fucking, north of where I grew up at Fort Wright, or is that no? Yeah, is that Fort Wright Air Base? Fort Pat. The air base up there. That's the fucking. It's a museum, but it's also an Air Force base. Like, okay, so you just read it, all read it. Like, yeah. Like, you're not getting like the Times. You didn't go to college here. Do you have what? Like, is it just like a History Channel subscription? Like, nope. Like, okay, so you just don't know shit. Also, my chair is fucking broken again. I might have to replace this fucking thing. It's not a good place to be, okay? Especially if you're going to be doing commentary all the time, because you are going to be wrong. And the thing is it's easy to attack lefty audiences, and lefties don't like it when you do it because it's the easiest way to attack them. But the thing is an effective tactic is not going to be ignored by the people who you're enemies with, just because, you do it when you're hanging out with other people. Empanada's audience, and if you're out there, you guys are really fucking stupid. And you know next to nothing about America, like 9% of the time, 90% of the time. And I don't mean like, you're not aware of war crimes and stuff. You guys just don't know how it works. You guys don't know where the Mississippi River is. Do you know what I mean? Like, you don't know what the Emancipation Proclamation is, or when it was maybe in the ballpark of written. Like, you've heard of the Civil War, but you can't remember the difference between like the Union and the Confederacy type shit. Like, and then when it gets deeper into that, and I start talking, because like I had the same thing, Canadian filth, fucking Noah Driver. Like, do you know what the Articles of the Constitution are? And like, you people, foreigners will not, you don't look up the whole Constitution. You don't know how the fucking states and stuff interact. And you don't know how the legal system works, but then you make like big proclamatory sentences because you think you're an honorary American because you're on YouTube, I think is what it is. You feel like you're an honorary American or some shit. I don't know. You watched a bunch of Arnold Schwarzenegger movies or something when you were a kid, and now you're having your moment. Is this still going down? God, I fucking hate this chair. I'm getting very frustrated with it. And if you're mad at me, go ahead and be mad at me. I think I have to talk this out with some people, but like, fuck. Okay, so this is the post that kind of was like, oh god, it's in my wheelhouse too, but we'll hop into it. So this is from less than a day ago. Ban Up and Not Alive. I keep seeing people say that h3h3 set some sort of precedent for fair use on YouTube by winning the Matt Haas lawsuit, or even that they basically established fair use on YouTube as a result of that. That's a very weird thing to say. This is not true. Fair use exemptions have existed for as long as common law copyright law has. The U.S. 1976 Copyright Act had these exemptions in it, and this already applied to all audiovisual media, which meant YouTube as well. Fair use is decided on a case-by-case basis. This is how it was both before and after their case. Okay, how to hammer that down. How to hammer that statement down. So, I'll finish reading this in a second. The main things, if you are going to talk about a case, a court case, a good thing to do is look it up. Because you got to tell people what the fuck is happening in the case. Yes, the 1976 U.S. Copyright Act had those exemptions in it. They were further established by other sources. The copyright law goes back for decades. Watch my 5-hour breakdown on this stuff when I was fucking irritated by Dark Viper AU. Yet another foreigner speaking on my country's glorious constitution. You hate it, you should at least know about it, right? The major issues at play were not the United States Copyright Act, although aspects of that came in. It was the Digital Millennium Copyright Act, which was like from like 2001-ish, and then has additional provisions going forward, okay? So if you look up the case, there's 3 issues specifically. It was, did under the Digital Millennium Copyright Act, and I looked up the case and read through it last night and double-checked it, did the content violate Matt Haas's copyright under the DMCA? Under the DMCA, did the Kleins falsely claim that they did not violate the copyright of somebody else and therefore make a civilly actionable false claim that they have the copyright to it, which is an aspect of the Digital Millennium Copyright Act. This is why it's lightly precedential, but I'll get into the definition of precedent too. And then third, there was actually an aspect of defamation against the Kleins for suggesting that they were being sued for false reasons. Basically, you can't talk about this case when you're being sued and say that you're suing me or I'm suing you for an inappropriate reason when I'm suing you for an appropriate reason. You're defaming me. So there's 3 issues at hand. Copyright violation, a false DMCA claim on behalf of the Kleins that they owned the content that was fair use, and a defamation claim. So those are the 3 main claims. And there's actually, I only read this the first time last night. You can actually still make the same fucking argument that Ben Empanada wants to make. He's a foreigner and he's also stupid. Australians, what can I say? It's fucking right there because the judge says a number of times that the Kleins were wrong in almost all of their assertions, but they still got ruled in favor of. They just didn't have any fucking understanding of what they were supposed to be saying. So we'll get to that. I'm going to finish reading BEMP's shit right here. They won their case because it was tested against the 4 factors of fair use exemption outlined in the Copyright Act for criticism, news reporting, teaching, blah, 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 found not to be infringing. Hold on. 4 factors of fair use outlined in the Copyright Act for... Oh. You're reading this wrong. This is always done on a case-by-case basis, and they did not set any special precedents in this regard. They did. They sent an argumentative precedent, a persuasive precedent. I'll get to that. At most, they reaffirmed the decision of Lenz v. Universal Music Court, which dates back to 2007. Can I just search this? Okay. It actually is mentioned twice in this, but that's not the substance of the issue at hand. At most, they reaffirmed the decision of Lenz v. Universal Music Court, which dates back to 2007, and which had already made it illegal to issue DMCA takedown notices without first considering fair use exemptions. But this is just in relation to improper abuse of the DMCA system, not the actual application of fair use to YouTube or online content, nor what does or does not constitute fair use. Again, even this part was reaffirming a precedent, not setting one. Fair use, which is like, why didn't you just read it? Fair use always applied to YouTube, and whether something constitutes fair use is decided on a case-by-case basis by a test versus the 4 parameters outlined in the Copyright Act. Not an Ethan Klein court case. Are those actually outlined in the act? Or were they established later? I can't remember. But yeah, the premise is, I don't know why he doesn't bring those up here, by the way. Because that's one of the main things with copyright is that because of each one, never mind, hold on, I just got to get to precedent. The only reason anyone ever believed that their case was at all important or precedent setting is because Ethan and Hila themselves sold it as such. This is not remotely true. That's not people who followed it that were legal scholars talked about it. It's not quite like Plessy versus Ferguson. Do you know what I mean? It's not like Dred Scott, obviously, and it's not a binding precedent, but I'll get to that. It was a victory for them personally and their own rights, but did little to nothing for anyone else going forward. Okay, so this is massively a breakdown. So if you want to read the entire 21-page, it's a little bit more complicated than he let on. This is the entire 21-page decision handed down by Catherine B. Forrest as part of the summary, I believe, judgment that dismissed every single thing against Matt Hossenzada, right? Hossenzada. Oh, I should probably do precedent first, though. So we'll go here. Yeah, judge sides with Ethan Klein, TechCrunch. This got added to the thing. Blah, blah, blah. Where is precedent? Come on. I know I have that up here. Nice protests. Fair use. There we go. Okay. So we just go to legal dictionary. I checked this at a few different ones. It's all over the place. I looked at Thomson Reuters. I looked at fucking, I think, Lexis as well. But it's pretty set down. So definition of precedent, right? A legal decision made by a court of authority which serves as an authoritative rule in future similar cases, a rule of law established by a higher court that is subsequently referred to in deciding similar cases. What is a precedent in law? Bada 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 bada. Damn it, do I have the wrong one up here? I probably fucking do. Where do I have to go? Oh yeah, okay, here we go. So yeah, binding precedent is probably what Ben Empanada is thinking about, okay? So a binding precedent, the way that laws or courts work in America, okay, is they are hierarchical. And both the states and the federal level, okay? And you don't always go to the federal level for stuff. A lot of things just terminate at the state Supreme Court. Some things can and some things can't, and there's a bunch going on. Between the various many courts at the state level and the eventual state Supreme Court, which we'll stick with in this case, are appellate courts and various other higher courts. Usually, but we'll just say lower court, appellate court, Supreme Court. We'll just go with just those basic three right now. So when a higher court makes a decision, that's called a binding precedent for the lower courts, right? Basically to say that, okay, this is how we're doing it now. That's really what it is. That's what a precedent is, okay? Binding precedent means that you have to abide by that going down, because if you don't abide by it, you have to basically, you're going by ear. But binding precedents also aren't necessarily binding, as in like if it's even remotely like that, you have to do it. You work around it, okay? So when you see legal arguments, you won't see just this is simply reaffirming the decision from 2007. You will see a series of court cases. As I'll scroll through the judge's decision, which is 21 pages. Some of those are binding, right? They are binding court cases, and some of them aren't. Now, even the binding court cases aren't necessarily permanent, such as Roe v. Wade, such as Miranda v. California? I can't remember. The Miranda rights case. The Miranda rights case was binding because people are like, you have to have your Miranda rights read. But then that binding precedent slowly but surely got disintegrated because of persuasive precedents, which is what we're talking about here, right? So basically people argued around the fundamentals of it to the point where people said, well, subjectively speaking, in that case, it's binding, but there's so many other use cases around it, and so much stuff has changed since that time that that's no longer as binding of a precedent that everybody has to really abide by. It's not like a fucking perfect trap card. What the Klein case set was a persuasive precedent, okay? Persuasive precedents are not binding because they're from a lower court. but you'll hear this phrase all the time. The Supreme Court is going to hold with the lower court's decision in X. Okay? That is a very big thing. So anybody that comes in here, this precedent for this case is a persuasive precedent. So this whole case can get brought up. Klein, h3h3 versus Matt Hosmanzada or whatever it is. It can be brought up as a very, very strong argument for a series of issues. One of them is a decisive issue, which we're going to skip to down here. Now, it doesn't mean that the court has to agree with it, but if they don't agree with it, they can actually vacate decisions sometimes and reopen stuff. So they usually won't. The people that are making persuasive precedent arguments, this is, in this case, a judge handing down a decision in a summary judgment, which is, it's not a jury decision. It's a summary judgment. So it's very intense, is giving her literal legal opinion on the matter. So the higher court would have to vacate her legal opinion if they are presented with the exact same circumstances or such similar circumstances and find that decision unwarranted. They could vacate that decision. So you hear about they vacated the decision made in X and held actually this, all right, which would be a further precedent set. Then that court could go to a higher court all the way up to Supreme, and it could go back and forth the whole way. But that first persuasive precedent is both a legal framework for making an argument that did not exist and that the H3 Productions people paid for the moment to happen, basically, and didn't bow out. And then it's there now. And the major thing that that we're going to focus on, and you can read the whole deal on your own, is not just the establishment of fair use. You'd have to be a stupid person to say that. But most people don't understand fair use. Ban Empanada did not provide a pretty, like he did not seem like he understands what it is. He definitely didn't explain it. He didn't even give the 4 criteria. He just said the use and commentary. Oh, that's extra hootenanny. It's the amount of what is used. It is the character of use. It's the infringement on the market. And the nature of the transformative nature of the use, right? All of these things can be weighed independently. One of the major aspects of this case is, and why it's defending free speech on YouTube and establishing rules, is that the Digital Millennium Copyright Act changes the way and sets down rules for the way that content is owned, and conversations around content in a legal and civil sense happen at the legal level, and what people that are these platforms can do. Because basically you have to put YouTube in a position where YouTube collects a legal statement as a part of the DMCA. If you didn't know that, when you say that's mine, you actually make a statement under the Digital Millennium Copyright Act to YouTube that is under penalty of perjury if you lie to say that it's yours. You also do the same thing to say that it's not theirs. Do you know what I mean? And they do the same thing back to you. You have to make legal statements, and eventually it will have to go to the courts if you keep pursuing it. This is different than how free speech and fair use works in the normal world, because it's a different setup. That's why we have a whole different rule. Digital Millennium Copyright Act. All of this is about free use or fair use and free speech underneath the Digital Millennium Copyright Act. And this is actually a pretty massive decision on this judge's part. Now, is it holding with the law? Yes, it is not going to. I don't know why you would even suggest the possibility that it's going to divulge or diverge greatly or some way from the law or change things. The law is pretty solid. We have the best free speech protections on earth in America. As far as I know, compared to all the rest of y'all, they're pretty solid. So a judge going outside, she would have to do something fucking insane to kind of change things forever. But even the Hosmanzada's lawyer, lawyers are going to say what they say, was like, no, this is actually fucking crazy, and the judge permanently changed the nature of how content and intellectual property exists in this part of California. So Summary decision, translation, get this horse shit out of my docket. It's too stupid for me to waste my time. No, not necessarily. Summary judgment really just means you can do that in civil court. We don't want to go jury trial. We think that both sides of us think that we have the best possible case. It's going to be probably too complicated or long. It's going to be really expensive for us to do a jury trial. It's going to take fucking forever. And then we're going to have the jury deliberate on it. And I would rather defer to the legal position or the legal opinion of the judge, because I think I'm so in the right, than I would rather waste time with a jury, right? Because the jury's going to be a crapshoot, because who knows how many fucking bad Empanada viewers you might have, or h3h3 viewers who are going to have like fundamental civics concepts painstakingly explained to them so that they understand what the fuck they're supposed to decide when all the facts are presented. So in this case, I'm not going to go through all the background. It's a lot to read through. Well, I'll put it in. Relatively found to be determinative, calls for recognition. Davis. I mean, if you want to see all these, by the way, I don't know why he said like the court's holding with just that one thing. The court's holding with all of these. All of these precedents, right? All of these. Some of these are persuasive. Some of these are binding. All of these precedents the court is holding with, because it's a lower court, so they can't really. They can go in a different direction, but like they can't really like change it, like So it wouldn't be upheld. They're just saying they agree with the thing. These are all over the place. All the fuck over the place. This is a ton. So DMCA misrepresentation. I want to bring this up. So this is one of the most important parts of this. Okay, and this is going to get a little complicated, but to summarize it, what h3h3 versus Haas established is that in the DMCA takedown notice, having a good faith claim on your side, saying that that's my copyright material, right? That's all that's needed to have that claim be civilly acceptable, right? They were saying that if you make a bad faith claim under the Digital Millennium Copyright Act, by the way, you can be liable for civil penalties, right? And even perjury, which is a criminal issue, because that's what the fucking act says, right? What they are arguing in the civil case, Haas's lawyers, the plaintiff in this case, is that the Kleins, H3H3 Productions, made a incorrect and bad faith claim that this was fair use, right? So based on the fact that it wasn't fair use in the opinion of the person who owns it. This is very significant because basically what they were trying to establish is an uneven playing field between rights holders, or at least rights claimants on the plaintiff side, and defendant side claimants, right? To basically say, well, the law says you have to have a good faith claim to make the claim, but if you're putting the defense on the position that they have to be correct, or they've made a false claim and are civilly liable for it, then basically you're saying that they're going to be up for a serious penalty if they defend themselves at all and lose even if they're correct. This is at the heart of the issue, and it's one of the biggest reasons it's a whole fucking thing, right? It's also the character. The judge established that React content as presented by the Kleins is sufficient, and basically all of the arguments you see the plaintiff's lawyers make, the judge rejected a lot of them categorically. They rejected a lot of Ethan Klein's arguments categorically as well, or the H3H3's claims in addition. It seemed like, this is the thing, DMCA, it's old in, terms of a human life, whatever, about a quarter century, but as far as law goes, the common law system was established with like Magna Carta and maybe even further back. Like our legal history as in the Anglosphere is like pushing millennia old. You get what I'm saying? These are new ways to approach old concepts. And so not everybody knows how to make the argument correctly. And that's why this is a big thing. When this is established, Now you can reuse this persuasive precedent in order to argue on behalf of yourself, and you also don't have to have as much legal ass behind you because all of the work's been done. This is the value of a persuasive precedent. Even your own lawyer isn't going to have to go in and look up all of this shit for the first fucking time. They're going to be able to follow the court's former decision and say like, hey, this is what this court decided. This is why this is so similar to our case. And we think that you should hold with the same decision that they made because these cases are so similar. Also, the slight discrepancies here are answered this way, this way, this way, and this way, which basically closes up the ability of rights holders, so to say, to claim against you and then also hold you liable if you defend yourself, whether or not you're correct, which is crazy. And that's what Haas was trying to fucking h3h3, now h3h3. He was really trying to fuck them because he was fucking pissed. He wanted to fuck them to death. So he was suing them for copyright infringement, for money damages, right? It wasn't just take it down. He was attacking them for full damages. And then he was also attacking them for violation of the DMCA by making a bad faith claim or an illegitimate DMCA claim to their own stuff. But the thing is that basically would set you up to be in a position where if you ever defended yourself based on your opinion, which is what it is, because fair use requires an opinionated assessment on a case-by-case basis of everything that comes up. So you have to have an opinion. You don't know it's fair use really, until a court decides with you based on persuasive precedents and binding precedents set earlier. And if those precedents don't exist, you have to make the argument for the first time yourself. It is a what you would call a cooling effect on defending your own ability to approach fair use if they would have won, basically establishing that if you don't win, you get sued. Would have been crazy. That would have been the other way. If Haas would have won, they would have established that under the DMCA, if you defend yourself against the DMCA claim and you lose, you are basically going to fucking also on top of the copyright claim get fucking obliterated for making a false DMCA claim. This was erroneous, and the courts decided this, as we'll read through here. That's a very significant thing. You could only learn about it by doing what we in America, at least, I don't know about Australians or Argentinians, call reading. And if you actually use the power of looking at documents with your fucking eyes and reading through them, you can find out what's inside of them. And then you can talk about it from what I call a position of knowing fucking anything at all and not sounding, and this is another Americanism, so if you foreigners are like trying to catch up, sound like a fucking idiot. So I'm going to go through this real quick. DMCA misrepresentation. By the way, this is the judge's decision. This is the judge's words, so kind of inarguable until you go to an appellate court. And I think the appellate courts, if I had to guess, considering we haven't seen this brought up, they would have held with this, which makes it, if they didn't take this to appeal, if they did, then those appellate courts held, then it is actually a binding precedent. If they brought this up to appeal and the appellate courts didn't take H3H3 back, then this would be a binding precedent. We haven't talked about it relative to the appeals court. I didn't look that up, so I don't know for sure. If I was Haas, I would not have wasted the money trying to do that. But might have been cool because then we could have got a binding precedent underneath the appellate courts of this jurisdiction for it. And then that would have been very, very strong outside and persuasive, if not binding because it's state to state, to other courts in other states, which would have been very interesting. The Digital Millennium Copyright Act, DMCA, governs the... And by the way, if I'm wrong about any of this and you're a lawyer or a First Amendment attorney or paralegal or something, please, you can make a response. But if you're anyone that wants to argue about this with me, please cite something. I don't want to hear your opinion. Just show me where the fucking actual change in facts are. I don't care about your interpretation of the event because I can just read the judges. And I'm repeating that. Okay. Governs by which copyright holders can notify online service providers that their sites host or provide access to allegedly infringing material. The DMCA provides that such notices, commonly referred to as takedown notices, must include, inter alia, a statement that the complaining party has a good faith belief the use of the material in the manner complained of is not authorized by the copyright owner. 17 U.S.C. 512, Section 3, Section C3AV emphasis added. The DMCA further provides a mechanism commonly referred to as a counter notification, through which creators of allegedly infringing work can effectively appeal a service provider's decision to remove or otherwise disable access to their work. Similar to a takedown notice, a counter notification must include, inter alia, a statement under penalty of perjury that the subscriber has a good faith belief that the material was removed or disabled as a result of mistake or misidentification of the material to be removed or disabled. 17 U.S.C. 512 G3C. Emphasis added. Relevant to the current action, the DMCA prohibits, quote, knowingly materially representing, 1, that material or activity is infringing, or 2, that material activity was removed or disabled by mistake or misidentification. 17 U.S.C. Section 512F. The Ninth Circuit has held that, in submitting a takedown notification, a copyright holder need only form a subjective good faith belief that a use is not authorized. Lens v. Universal Music Corp. 815 F 3D 1145 blah 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 blah. Cert denied. 79 blah 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 blah. In other words, a copyright holder is not liable for misrepresentation under the DMCA if they subjectively believe the identified material infringes on the copyright, even if that belief is ultimately mistaken. C. It is clear to this course that the same subjective standard should apply to the good faith belief requirement for counter notifications. C. The counter notification good faith belief. So we went one way, now the other. If the same standard did not apply, so that this is the part that matters. It's clear to this court that the same subjective standard should apply to the good faith belief requirement for counter notifications. That's like the whole thing. You got to find that one fucking sentence, right? If the same standard did not apply, creators of allegedly infringing work would face a disparate and inequitable burden in appealing an online service provider's decision to remove or disable access to their work. Given the fact that the statutory requirements for takedown notices and counter notifications are substantially the same, the DMCA plainly does not envision such a scheme. CF Rossi, this juxtaposing the good faith proviso of the DMCA with the knowing misrepresentation provision of that same statute, reveals an apparent statutory structure that predicated the imposition of liability upon copyright owners only for knowing misrepresentations regarding allegedly infringing websites. Because falsity... Okay, so that's it. You can be as wrong as you like on the internet. Everyone else is. We don't read in Australia. It's against the law. So it's not a holding with, because the last decision wasn't for that. It was based on this decision. This same thing would be in the opposite direction, the same deal. Okay, everybody knew about the Lens v. Music, bubbada, bubbada, bubbada. But that's not the argument that they made, right? That held, and they used it. That's the kind of the point of these persuasive deals. So in this decision, that's made, as well as a number of other small issues, right? Each time you do copyright stuff, the amount of each four is gone into. I could actually probably just scroll up and go over it real quick. Fair use. Fair use is an affirmative defense to copyright infringement. It's a judicially created doctrine, first explicitly recognized in statute in the Copyright Act of 1976 on Davis and Gap Incorporated, in determining whether the use of any work in any particular case is fair use. Courts must consider non-exhaustive factors. Here's your four. Nature of the copyrighted work, the purpose and character of the use, including whether such use is of commercial nature or for nonprofit educational purposes, the amount and substantiability of the portion used in relation to the copyrighted work as a whole, and the effect of the use on the potential market for or value of the copyrighted work. I might have misstated those earlier. No single factor is categorically determinative in this open-ended and context-sensitive inquiry. Then you got all these guys. The task for determining fair use is not to be simplified with bright line rules for statute calls by case-by-case analysis, which is sort of the thing. That kind of basically means that for all of these little tiny decisions that are made relative to copyright stuff, that the case is very important because in that specific use, that type of use, we've now established that that's fair use. So we don't have to have the lawsuit again. That's the big thing of a persuasive argument. Is this as big as, whatever the fuck, any of these major binding precedents that go up to the Supreme Court? No. I don't know who made that argument. Was this big for YouTubers? Yes. Because if they would have lost, it would have gone the other way. If they would have lost, then, which they could have, by the way. They could have lost because they were actually pretty incompetent here. I don't know if I'll find the arguments part because it's all fucking in through. But basically, the Kleins sort of argued counter effectively to what they were supposed to be saying relative to the content amount and stuff. I think one of them was that, you know, their video is 17 minutes long and the amount of video that's used for Matt Haas is only 3 minutes, but that's not actually how you are supposed to argue with that. The material of the work in question is more important than the amount of material of the use work, right? Because a song is only like 3 minutes long, but if you illegally use a song in a video, then the whole video can get cracked, right? Which I didn't do, by the way, so y'all are lucky. That's kind of the point. It's how much of the use relative to the character of the use is there. And so some of these arguments were that, and this is crazy because the fucking Kleins have gone against this actual standpoint with their takedown notices against Reddit, that criticism and criticality, even if you say, it's in here too, even if you say, I want to present this to other people so that they don't want to watch it, scathing criticism and replay does not actually, even though it's in the same market, count as an infringement on that market, right? You have to be, it even has to be presented as basically replacing the original work. So you would have to be infringing on him, not necessarily not making fun of it, but like literally doing the whole thing again. In the case of Matt Haas, the characterization of the work has to be completely fucking different. So like the Kleins argument was wrong, which might have been one of the reasons it took them forever to get through this shit. The real story is the Kleins have always been fucking up, and this judge kind of like read the law better than everybody. All these YouTubers are stupid as shit. But if it hadn't gone this way, then what the courts could have decided is that, like, he's right. Also, if he would have gotten bullied, if the Kleins had to go to court, by the way, also, I want you to really understand this. They had to go to court because the DMCA makes you, right? So every time before this or after this, if they had fallen over and surrendered and stuff, everything that this guy's lawyer did, that lawyer or anyone else could do again. That's kind of the point. That's what persuasive precedent is, or a non-stated precedent in this case, just a de facto precedent. If they would have sued and then the Kleins would have just settled and walked or you know, lost, then we would have established something else, which would have been that, no, actually, the DMCA, you are fucked. If you fight back, you're fucked. Actually, no, this kind of React content is blah, 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 and all this sort of stuff. This is how precedents and persuasive precedents and the legal system works. This is fundamental, but you do have to go through the system because the DMCA hits a wall that is, you go to court, basically. Like, and they went. I've had stuff and I pushed it in Universal Music Group. I think it says it was Kanye West. It was me singing something. It was like, yeah, if you do the next thing, we're going to give you a copyright strike and you have to go to court. So I'm like, oh, okay, well, fuck. Goddamn. I'm not, who gives a shit? You know what I'm saying? If they would have hit him with that at that high of a level and that specific kind of content, it would have destroyed people's ability to comfortably engage with it at the time. Is it establishing First Amendment rights or free speech or fair use? No. Stupid people say stupid shit all the time. Y'all are dumb as fuck too. You're not that much better than h3h3 fans. Understand? Like, a lot of people that are outside of these spheres looking into the Hassan sphere, h3h3 sphere fight see the same clowns fucking smashing each other in the face with a series of lemon meringue pies. But we'll kind of go down. Second court is held when the material facts in the record are undisputed. Fair use factors are properly considered as a matter of law and therefore may be decided on motion for summary judgment. Although fair use is a mixed question of law and fact, this court has on a number of occasions resolved fair use determinations at the summary judgment stage where there are no genuine issues of material fact. Internal quotations and alterations admitted. Swatch Group, Management Servers Limited versus Bloomberg LP. Affirming district court's sua sponte grant of summary judgment for defendants on basis of fair use. Although no factor is independently determinative, the heart of the fair use inquiry is the first factor. Whether the use is transformative by adding something new with a further purpose or different character. On Davis, quoting Campbell, the central purpose of this investigation is to see whether the new work merely supersedes the objects of the original creation or instead adds something new. with a further purpose or different character, altering the first with a new expression, meaning, or message. So this is why I say a lot of the commentary community people are going to get fucked at some point because they use, I don't know why they feel comfortable doing it, but people steal music all the time. And understand, music, if you're not providing any commentary on it, it's music. So if you're just listening to it and enjoying it, you're using it for its original purpose pretty much universally. Like it's meant to be heard, which is one of the reasons music's the easiest to hit. And also fucking music lawyers have nothing but free time because they're not making new good shit. That's kind of the aspect. So you're like, well, my video is fucking 5 hours long. It's only 3 minutes of this. Yeah, but you use the song as a song, right? Because you enjoy it, because it's a good song. So that's copyright infringement if you haven't paid for the rights or done some other sort of thing. If you're talking about it, okay, sure. But that's why you can also watch 6 hours of somebody else's content and make a few mealy mouth comments over it, and it's not hyper easy for them to get that taken down. Now, is a lot of that essentially fucking non-transformative, derivative, and probably violating copyright? Sure. But you wouldn't have any of that. And the thing is you always want the barrier to be pushed way further than where you're comfortable at so that you can remain comfortable. So it's always got to be, oh, so these shitheels get to enjoy this too? Yes. Yeah, because if they're the first ones that get hit by they're in the gray zone, I'm well outside of it. I'm in the no one's gonna kill me area. And that's extremely fucking important. Tyler, what you described is the difference between a judge trial and a jury trial. A summary judgment is something different where there is no disagreement in fact and clear application of the law. Okay, my bad. See, this is lawyer shit. A summary judgment is not even legally a trial, so to speak. Check the link I dropped in stream chat. Yeah, these are fucking, this is how much of this shit you gotta fucking know. Look at this. This is just the 56th rule, summary judgment. Look at all this. See this motherfucker? That's why it's easy to fuck up. And it's why lawyers take fucking forever to do anything. Motion for summary judgment or partial summary judgment. A party may move for summary judgment, identifying each claim or defense on the part of each claim. Summary judgment is sought. Court can... God damn it, that's fucking tiny as shit. Here we go. Time is set. Procedures. Oh, yeah, I'm not even going to read all this. This is how much there is. And these are all the amendments. Look, this is... When you talk about... I was talking about, like, you know, the DMCA is new. We still use this 1946 amendment for these rules, right? They amend, and then they amend. It might go away, it might not. But a lot of these fucking civil rule procedure shits were fucking passed. Oh, actually, a bunch of stuff was redone in the 80s. Or was it the 70s? The Paper Act. Dude, it's very, very, very complicated. But a lot of these things hang on. And even some of the old laws that are not on the books anymore will come back up because... Well, we decided this once before, and then when we changed the law, this wasn't a part of it, but I don't know, if it ain't broke, don't fix it. Can we just re-add this shit? And then they will. You know what I mean? They're nuts. This is how much you need to know. So, okay. Mea culpa. I was talking about a judge trial, not a summary judgment. Summary judgment is usually, as I remember, it ends it. Basically. Like, okay, we're just going to go done. Fucking very complicated. Where the hell did my chat go? This is the idea of a living legal system. Basically, it adapts and changes based on the conditions decisions are made. Fun fact, the lawyer who represented the clients in that case is the same guy who wrote the cease and desist letters to Redditors and Noah Samson. Is it? I thought it was a different guy. Either way, lawyers are lawyers, man. They get paid to work, not be good people. Oh, it looks like the Vegas YouTuber shooting was a feud over copyright strikes. Tremendous. Imagine being in court debating copyright and then having to take a long recess because everyone caught Giardia. True. Legal positivism is the idea that the law is whatever the judge decides on a case-by-case basis. U.S. federalism and legal positivism would create chaos. It did for a lot of U.S. history. Precedent and legislation are supposed to limit the potential of abuse by the courts, i.e. avoiding a system of legal positivism. Yes, which you hear the fucking our current people going into all the time. So they're always trying to, they want actually legal positive. They want to have a judge that gives them their judgment, right? And if you go in all those different directions, it's fucking crazy. Legal positivism, we're basically just making a fucking, judges getting to judge however they feel to kind of like keep their people happy where they are. It's fine when everybody's kind of disconnected and you got to like, hey man, we just do things different here in Mayberry. You know what I mean? But like once everybody starts getting interconnected, you have to update shit. When I was reading back on the legal system, this is a few months ago, basically how America's legal system got updated through the 30s through 70s up to the Paperwork Act. Essentially, we ran down to the county was different throughout most of America, and everything past the Mississippi was fucking insane. There was no standardized way to pass the bar. What the bar meant was completely different place by place. How you could become a lawyer, what training was for a lawyer, what you had to do and couldn't do to be a judge, all sorts of different stuff was like all over the place, even to the point of like people would just write laws down in books and no one would vote on it and it would just be the law because somebody was like, I'm just going to write it down, which sounds like insane, but it was the Wild West all like into the early 1900s. You know what I mean? So like, and then once that has to get, resolved, that's where a lot of this even ongoing conflict between the states and the federal government comes from, is that states were doing whatever they wanted to do. In a lot of cases, that doesn't mean the state. It just means whoever had kind of like decided to start treating the fucking state like his own robber barony, and his family and other individuals that were part of that same like clan would be like, oh, well, we always do this like this and it benefits us. And then the people that fucking live under us don't seem to give a shit. So we want to keep doing that. And then the federal government's like, well, we'll stop giving you money. And then we have other conflict. It's very, 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 very complicated, ultimately. But let's see. Did I get this? Where was I? Yeah, he's also Israeli. He was definitely part of YBE. He's mad. I was wondering why Tyler was staring at the screen so intently, but it was just because I paused the video. Okay. The central purpose of this investigation is to see whether the new work merely supersedes the objects. It's well established. Let me see. Usage. I want to find this part. Okay, yeah. So this is where you start getting to the decisions and stuff. Second factor examines the nature. I read it out of order. Well, actually, I read it in order, but in the wrong place. Allegedly infringed work. Defense argue that the Haas video and plaintiff's bold guy video skits are factual rather than creative in nature because plaintiff has said he draws inspiration for the character from his own experience and personality. The court disagrees. Very funny. This is their argument. This is their argument as the defense. So this is why this shit is like. I was cackling while I was reading this. This is the main reason I wanted to start this segment. Actually, I don't give that shit about bad Empanada. I just wanted to be mean to him. The second factor examines the nature of the allegedly infringing work. Defendants argue that the Haas video and plaintiff's bold guy video skits are factual rather than creative in nature because plaintiff has said he draws inspiration for the character from his own experiences and personality. The court disagrees. Plaintiff's videos, including the Haas video, are entirely scripted and fictional, regardless of whether plaintiff draws on himself for the bold guy character. If creative works were deemed nonfiction whenever an author relies on his or her own experience, the fiction genre would be defined almost entirely out of existence. Since the Haas video is a creative work, the second factor weighs against a finding of fair use. There's gold in here. Because it feels like when I'm reading it, my mind wants to just say like, okay, so this is what Ethan and Hila literally said, but I think this is their fucking lawyer, was just like, this isn't a creative work because it's based on the guy's own life. And then the judge had to like hold this moron's hand and go like, no, honey, no, they made parts of it up. This is it's creative. It's fictional. Do you know how like you know how like the movie Trumbo about Dalton Trumbo, he wasn't really fucking the guy from Breaking Bad. It's still a creative work, even though it's based on reality. It's based on a true story. That's crazy to me. Like, there's such a good argument to be made against the Kleins getting patted on the back here, and it's because they almost completely fucked it up. That's the thing to talk about. There's more than one of these. The court held that they were correct against all of their own arguments, which the court had to just hastily cross out and then rewrite in the correct answers. Which is fucking tremendous. Like this guy, dude, this is Lionel Hutz just going, wait, I won? I won! We hold in favor of the defense. Well, I'm sorry, but I guess I lost another one. Well, good luck to you guys. But no, you won. I did what now? I don't know what to do. The third factor examines the amount and substantiality of the portion of the copyright work used. Defendants argue that the third factor weighs in their favor because plaintiff's video constitutes only a small portion of the content of the defendant's video. Defendant's analysis gets the math backwards. They're just getting rocked. You fucking fuck-ups. Defendants argue that the third factor weighs in their favor because plaintiff's video constitutes only a small proportion of the content of the defendant's video. Defendant's analysis gets the math backwards. The third fair use factor considers what proportion of the copyrighted work the allegedly infringing work uses, and then how well tailored that use was to the allegedly infringing work's proper purpose, no matter how large or long the allegedly infringing work is. That's like you failed. You in representing your case said the opposite of what you should have said twice. Fucking awesome. Actually, you're completely backwards. The judge is like, you're fucking lucky I'm here. You like, this is where, dipshit, you should have read the whole fucking thing. Or any of it at all. This is gold. This is gold. The Kleins almost fucked up everything for all of YouTube is the actual response. They presented an argument that was the opposite of the argument that they had to make, and if it wasn't for the summary judgment actions of the judge themselves, they would have lost. Do you know, like, they argue, if it was a test, they got all the answers wrong on laws, which are written down. It's written down. So he didn't, like, look it up. What the fuck is going on here? I mean, like, this is how I would get scored. Your fight, this is hundreds of thousands of dollars, millions on the line, YouTube careers, and kind of like the legal steadfastness of an entire industry was on the shoulders of Ethan Klein and his legal team, and he failed. He failed completely. They didn't, the judge did it. The judge did it. They fucked up completely. The judge did it. Which is the real story. This is what I'm talking about with Bad Empanada fucking up. The big one is that just trying to muddy the facts because you barely understand what the fuck you're talking about and try to like, oh, the good thing that I did was actually a bad thing is nowhere near as funny as just reading the fucking document and then the fucking judge literally hand-holding them to say, you keep saying the opposite thing, honey. This judge caught YouTube in her fucking hands and gently held it on her shoulder while fucking the clines were dangling from the bottom of it like so many fucking lamprey. That fucking idiots. You got the math backwards. Actually, the complete opposite is true. Like, no one, the fucking, dude, Matt Hosh's attorney must have been like, man, what the fuck, Your Honor? She's like, hey, look, I get what you were trying to do. And I know that whatever the fuck is going on here is pretty crazy. But this is bonkers. Understand, if you just had like 10 seconds of paying the fuck attention to what you were talking about, BEMP, you would have had him. You had him right there. This is what the fuck happens with the left all the fucking time. Just get in there. There's gold. Just do your fucking research. Stop fucking getting sent clips on Reddit and in your DMs and then just fucking half-dicking other people's revolution. Motherfuck. Oh my God, man. Here, defendants use a number of short segments of the plaintiff's work, interspersing their commentary and critique along the way. It is certainly true that when one adds up all the segments used, the total amounts to 3 minutes and 15 seconds of a 5-minute and 24-second video. The law is clear, however, that quantity alone is not determinative. Counsel. It is evident that to comment on and critique a work, clips of the original may be used. Campbell, this 510 U.S. at 588. Parody must be able to conjure up at least enough of that original to make the object of its critical wit recognizable. Copying does not become excessive in relation to the parodic purpose, merely because the portion taken was the original's heart. Abilene Music Inc. versus Sony Music Entertainment Inc. 320F Supplemental 2D 8489 SDNY 2003. See, this is over in fucking New York. Southern District, New York, 2003. So this is, you get to go side to side to side to side. I don't know if that means supplemental. A parody must take recognizable material from the original in order to convey its message. Without using actual clips, the commentary and critique here would lose context and utility. Here, the extent and quality and importance of the video clips used by the defendants were reasonable to accomplish the transformative purpose of critical commentary. See McCollum 839 F3D at 185. The factor is therefore neutral. A great deal of the plaintiff's work was copied, but such copying was plainly necessary to the commentary and critique. So this is a non-deciding factor. Non-factor, right? So it could still up, down, whatever. The fourth factor, commercial impact to the allegedly infringing work has on demand for the Haas video also weighs in favor of the defendants. The purpose of the fourth factor is to determine what degree an allegedly infringing work usurps demand for the copyrighted work, thereby resulting in a loss for the infringee or unjust enrichment for the infringer. U.S. at 592 stating the role of the courts is to distinguish between biting criticism and that merely suppresses demand and copyright infringement, which usurps it. Internal quotations and alterations omitted. Nexium Corp. I think that's Nexium, right? What the fuck? In considering the fourth factor, our concern is not whether the secondary use suppresses or even destroys the market for the original work or its potential derivatives, but whether the secondary use usurps the market of the original work. Here, it is clear to the court that the Klein video does not serve as a market substitute for the Haas video. Anyone seeking to enjoy Bold Guy v. Parkour Girl on its own will have a very different experience watching the Klein video, which responds to and transforms the Haas video from a skit into fodder for caustic moment-by-moment commentary and mockery. Because the Klein video does not offer a substitute for the original, it does not, and indeed cannot, usurp a market that properly belongs to the copyright holder. Fourth factor thus weighs in favor of a determination of fair use. Now understand, also, this is referenceable. This whole thing, all right? So the cool thing about this whole deal, right, and this is the good thing about a persuasive precedent, is that it has all of your work in it, right? So even if you don't have a lawyer, you should use a lawyer every time, but if you're like, I want to fucking raw dog a copyright response, you can say, well, you know, this seems like this thing. Or you can even just look at this and try to figure out if it's correct or not. And even if you're a lawyer, then it really, really helps because now it does all your fucking work for you. And it says if you do all this work and you arrange all of these things together, this is all precedents. That's why they keep bringing up all these court cases and laws. Those are laws and precedents. Legislative, fucking judicial branches working together. 3 branches of government in America, by the way. I don't know if you knew that. When those little interconnected bits, that's how you make a legal argument, right? That's when you looking that stuff up and finding it. That's real lawyer shit. As a citizen of America, you should be able to look at a document like this and kind of at least understand what the fuck's going on. This is fundamental basic civics. You should be able to read a judgment from a court case and at least be able to like sort of follow along, kind of like you speak half of a language. Like, all right, I kind of get it, which is the same for me. I kind of get it. Usually the courts will try to help you to the fun parts by going like, you kind of wrote that shit backwards, didn't you, honey? Fucking 10 out of 10. Oh my God. Because the client video does not offer substitute, but yeah, you should check this shit out. This is claim 2 DMCA misrepresentation. Court has held that the client video constitutes fair use, and further that the client video does not infringe plaintiff's copyrights. Accordingly, it is clear to the court that claim 2, which alleges that defendants made misrepresentations to their DMCA counter for notifications, must also be dismissed. It is self-evident that a statement cannot be a misrepresentation for purposes of 17 U.S.C. 512F if it is factually accurate. But, and this is the point, this is the big thing, right? So this is like, okay, so we had it really like hammered. So we're given an actual opinion, a legal opinion on this regardless. So they would have been fine on this one. And this is the sort of the point why this case goes. Now, do you have to give the clients any credit for anything other than bulldogging it and just sticking with it? No, and nor should you, because they gave a bad argument. Their arguments fucking sucked. And this was 100% the judge interpreting the law. That's how you get them on this. Don't do all the extra stupid shit. Don't pretend like you're fucking writing for Supreme Court Monthly. The Kleins fucked it up. Legally, they fucking completely fumbled, but the goddamn judge was on the side of the actual law, picked up the ball, and fucking went all the way to the end zone. 95 fucking yard return. Like, for free speech. The judge is a fucking beast. The clients get attached to this because their name's there, and they do get the fucking recognition for being a part of it. But unironically, yeah, you can say that the funds that they raised were a waste because their fucking lawyer presented the wrong arguments. And the judge had to, like, look at it differently. If it had been a criminal case, like, they'd be in fucking jail. Do you know what I mean? Like... In other types of court case, the judge doesn't do necessarily all of this shit. Whoops, I just knocked over my fucking cornbread. So, like, the judge isn't going to fucking help you. Do you know what I mean? And they won't. I can't give you legal advice. I can't answer that question. I can only sort of, like, clarify this and that type deal. So, like, you wouldn't get that in other situations. If it would have been kind of, in a lot of different respects, they would have fucked it all up. Mad credit to them for sticking with it and fighting it, but now we can tell it's only just bulldogging this, and it's not valuable because they're so principled. It's valuable because we just happen to have a really good judge, and we got lucky as shit. Like, the clients could have gotten a different judge and fucked up YouTube for decades, right? Like, they could have gone in a different way because the arguments that were presented by their lawyer and them were literally wrong. They were bad arguments, and the court went, "Now I'm going to go ahead and disregard that." Like, what? If you're a fucking lawyer and I'm not interpreting this correctly, go for it. But I feel like, you know, if we're going to get into trying to do play pretend, well, we're all Destiny grade lawyers here. I feel like my interpretation is actually the most hilarious and damaging, because it's like, oh, actually, you guys raised all that money to just fumble? You did steroids just to tear your fucking hamstring on the first return? Like, what the fuck is going on? You suck. Oh my God, dude. It's just Michael Scott shaking the guy's hand. The court has held that the video constitutes fair use. Accordingly, is clear. Oh shit, what the hell? Why aren't you scrolling down? There we go. Self-evident statement cannot. But even if this court held the Klein video is not fair use, the court would still dismiss claim 2 because defendants clearly had a subjective good faith belief that their video did not infringe the plaintiff's copyrights. CF Lens, it is undisputed that defendants understand the concept of fair use and have an established practice for ensuring their videos make fair use of copyright materials. ECF, I wonder what that is. Number 101, It is also undisputed that the defendants filed a counter notification on August 26, 2016, alleging that the Klein video constituted fair use. This undisputed evidence clearly establishes the subjective good faith belief required under 17 U.S.C. 512G3C. Plaintiff has failed to proffer any evidence that suggests defendants lacked a subjective good faith belief, and therefore has failed to create a triable issue. Accordingly, Claim 2 must be additionally dismissed for that reason. Based. Claim 3, defamation, because, obviously if you hold with the other two, you can't get the defamation. Complete with non-actionable opinions. Absolutely project statement of pure opinion, such that they can never be defamatory. For example, Ethan Klein's statement, I think that the heart... Oh yeah, this is in New York too, by the way, not Los Angeles. I keep forgetting that. I think that the heart and soul of this is, he doesn't like that we made fun of him, so he's suing us. God, dude, there's such good quotes in here. Ethan Klein's statement, I think that the heart and soul of this is, he doesn't like that we made fun of him, so he's suing us, is quintessential statement of pure opinion. God, that's so good. Oh my God. Oh, fuck. It was a landmark. Yikes, that was close. It really is, dude. How do they have such a dumb lawyer? I'll say this before, I'm not a lawyer. I can't give you legal advice. You shouldn't even rely on me. Anything that you think is interesting that I say or even correct, go double check it and make sure. I'm going to make mistakes because this isn't my thing. I just find the law fascinating, and I think that it's everybody's who lives in a country's civic duty to understand the law to some degree so that they can interact with it safely, even just to follow it. But everything that I know about law is that where the money is where the lawyers are and where the expertise is. And fucking the First Amendment in America is such a strong protection, insanely strong protection, that there's not a lot of value in suing people underneath it, right? It's very difficult to the point where even when people started trying to do lawfare to force settlements with slaps, we immediately came up with slap suit stuff, which is anti-rich people of all things. It's one of the few anti-rich cunt laws we've ever passed in America, ever, is the anti-slap suit shit. The best lawyers for First Amendment stuff in America, as far as I know, are basically Hollywood copyright attorneys and New York City copyright attorneys who are hyper fixated on copyright issues specifically, and the fucking ACLU, and the ACLU is kind of really cooking. The ACLU wins a lot. Usually they take it all the way to the fucking home, all the way to the plate, and they get it because it's a big First Amendment thing. Civil liberties, right? Those are your civil liberties. You should know what the fuck they are and how much you can do with them. And to be a lawyer and be good at it, you have to be able to go to court cases and stuff. You know what I mean? You have to have a lot of decisions being handed down. But if you kind of see this, decisions in these are pretty rare and they're big and it's new DMCA stuff, but it's not very common that you need First Amendment lawyers. So compared to everything else, fucking last will and testament, obviously criminal civil actions for basic stuff. And even that, the First Amendment issues that might pop up relative to those are usually relative to the business laws or the, whatever sort of laws that are that the person's already kind of good at. It's oh yeah, so we have a First Amendment protection here, but I'm a business lawyer and we focus on this thing. This is called slandering people behind the ruining people's business connections type of libel, which is a special type of libel that people do on YouTube all the time. And someone's gonna get sued for it and killed. I swear to God, it's gonna be awesome. But an actual First Amendment case between two people who are you are abusing my free speech and is not hyper common. So you just don't have a lot of people. So I can kind of get all right, you're just, you kind of winging it. I mean, every lawyer has to go read the fucking Constitution, but being a First Amendment specialist means you're either going to be one of these jurisprudence dickheads that lives at Harvard and is just a dusty dude that teaches classes and stuff, and eventually he's on CNN once every 3 weeks talking about this or that. You work directly for the fucking Supreme Court or underneath it and you're a major politician, or you're not really out there. So it's kind of a big deal to have something like this because it smooths the workflow for other people to know okay, so this is how I go in and I argue this. Because you think about it, yeah, you're a lawyer, but a lawyer doesn't know what to argue until they know, right? They have to do their research. if you're in something like insurance, the insurance lawyers, we sue insurance companies every day to make sure that they get payouts. I got a unbroken lineage of like 15 partners who have trained everybody underneath them. We know everybody in the court system. We know this fucking law inside out. We have 150 fucking paralegals working on all this shit at the same time. We have the entire law library in here with fucking notes and stuff in it. And we know exactly what we're going to put together every fucking time to try to do this type, this type, this type, this type. Whereas opposed for something like, copyright infringement is like, YouTube copyright infringement is like, wait, they didn't just settle. They didn't just like leave. Like, no, we're fighting it. We're taking all this summary judgment. It's like, what the fuck is going to happen? Because before that, and by the way, if you remember 2016 era, that's AdSense and shit. And the first time the money started showing up on YouTube, there were people suing motherfuckers and saying like, I'm going to sue you. I remember, was it Philip DeFranco took something down because somebody said they were going to sue it, but it was way more common. So it was like, yo, I'm going to copyright claim this. And, if you think about it, you make a copyright claim back against me and you don't have the money, it's the ultimate slap suit setup, or like anti-slap or slap. Yeah. Fucking nuts. So it's like a very big deal that this stuff went through, and thank God the judge knew what was handed on their table, because like literally they're going to fuck this up. But I'm glad they didn't. I mean, I've used this. There's a post. If you look back through the H3H3 productions, there's a post of me saying I fought a copyright strike on a channel. I think it was actually this channel, but well before I ever started streaming and stuff, because I just uploaded a video of me singing a song or making fun of somebody, and then they copy struck me, and then I responded in it with using this thing. I was like, well, according to this precedent, I can say that. And I know that my stuff matches this shit in here, so I don't have to hire a lawyer. By the way, understand that every time you fill out a fucking copy claim thing, I said this at the top, you are making a statement of fact under penalty of perjury, right? For any copyright claim that you make. So having this case kind of establish these things, it lets you fuck up, make mistakes, and be comfortable in the fact that you're not going to have your fucking life ruined if you defend yourself. It's a very serious, very important piece of judicial like craft work, okay? And you actually don't have to give the Kleins any credit for it, because almost none of it was theirs except for them just being as stubborn as they are about literally everything else. That's where the argument is, and that's how you hit them. You can just say like, no, these incompetent fucks almost fucked it up for us. But thank God the judge literally says in her fucking decision, like, I'm going to go ahead and ignore the stupid thing you said because actually this is what's correct. Fucking awesome. But I'm not surprised that like the lawyers don't know that shit. And that's why it's good. Like I was saying. Nothing about Ethan Klein's statement suggests actionable mixed opinion. The only other allegedly defamatory statement explicitly identified by plaintiff is Ethan Klein's assertion that several months passed and nothing happened prior to plaintiff's first settlement offer and threat of litigation. But because that statement is substantially true as a matter of New York law, it is non-actionable. As previously noted, a statement is substantially true if the statement would not have a different effect on the mind of the reader from which the pleaded truth would have produced. Tannerite Sports LLC. I mean, I look at the thing he's holding with this. Holding with Tannerite Sports LLC. There's got to be something about a fucking bomb. Here, plaintiff argues that Ethan Klein's failure to mention that plaintiff sent a warning email on August 2nd, 2016 makes Ethan Klein's statement that nothing happened false and defamatory. Plaintiff further argues that Ethan Klein's omission is defamatory because it paints plaintiff as a trigger-happy litigant who immediately activates his lawyers when he is criticized. I mean, dude, there's so much good shit to use against Ethan, too, in here. Like, god damn. Plaintiff's mistaken for two reasons. First, viewing the lawsuit as a whole, clear import of the statement. Plaintiff's objection to the word nothing is hyperliteral and based on the strained and unsupported interpretation of the lawsuit video. Shout out Noah fucking Driver. Statement nothing happened can easily refer to Second, mention of warning email would not have produced a different effect on the mind of the reader from what the defendants actually said. Tannerite Sports, plaintiff's edge, reviewer, Clay's statement. Because the statement's dismiss. Conclusion. For foregoing reason, defense motion for summary judgment is granted in its entirety, and plaintiff's motion for partial summary judgment is denied. The clerk of court is directed to terminate the present action. So ordered. New York, August 23rd, 2017. So like that's kind of like the thing in a bit of a nutshell. We have, this is why I have this up here. Commentary from Ethan Klein. Okay, yeah. So this is a statement. This is why I have this up here. This is the lawyers at the time. Tim Bucker, one of Hossenzada's attorneys, sent us the following statement. We are, of course, disappointed with the outcome of the case. More importantly, the ruling profoundly changes the fair use doctrine in the Southern District. Now, secondary users are encouraged to sow virtually an entire copyrighted work and claim fair use so long as it is interspersed with jokes and seemingly relevant commentary. So, I mean, that kind of flies in the face of Empanada's interpretation of this, that this didn't change anything. The lawyers themselves are saying, this is the person that lost, says it changes everything. We are, of course, disappointed with the outcome of the case. More importantly, the ruling profoundly changes the fair use doctrine in the Southern District. Now, secondary users are encouraged to show virtually an entire copyrighted work and claim fair use so long as it is interspersed with jokes and seemingly relevant commentary. That's what most of us are doing that watch videos on this platform. That is literally, oh, wow, this changes everything. Now you can make fucking YouTube videos. Even if you don't like it and you want to make that shitty little baby excuse, like, oh, so it's like slop tube. We're doing the slop. This is the slop tube. We're sloppy sloppers. Sloppity slop sloppers. Like, fuck. Like, they're not going to be on your side for this. And they're the ones that you're going to have to attack. It's commentary stuff. Hassan's content that gets posted to YouTube is safe because of this decision. This decision protected chair streaming. Like, literally, it said, like, yeah, a little bit of commentary and all this fucking stuff, some jokes interspersed, is probably pretty fine. If they would have gone in a different direction, it would have been a different decision. If they would have fought it all the way to appeal, which they didn't feel like they had a good, I don't know if you can appeal. Can you appeal a summary judgment? I don't know. Now that I'm thinking about it. But like, if they would have fought it, more or brought up something else because they wanted to retry the same legal action in a different respect because of a different video or something like that, they could have tried to push for it in a different way. It could have gone a different way. And then we wouldn't have that type of content on YouTube, for better or for worse. But the thing is that extent, the shittiest version of it does protect all of the good stuff. We would not have a comfortable like Anthony Gramuglia having clips from fucking, I don't know, Sailor Moon in a video about Sailor Moon. We would not have comfortable FD Signifier putting clips from, whatever movie he's talking about or shows and stuff in a video because people would try to say that it's substantially different because it's YouTube instead of TV or some other sort of horse shittery. If you look at legal precedent or the way that legal decisions are made, a bad decision can hang around for forever and usually becomes a fucking six-shooter in the pockets of some fucking Republican cocksucker. And it's good that the courts went this way. Does it have anything to do with how good the clients are of people? No. Do they have a clear and evidenced love of the First Amendment for at times when it's not focused on them? I guess not now, which we've learned in the last couple months, right? Because it's kind of like, damn, Batman, quote, become the villain, whatever the fuck. But like, there's definitely a good place to attack them on this, and you don't have to destroy them. You just have to like, guys, come on, get the fuck back over here. This actionable, reasonable, like quotable thing, you guys fucking literally went here and made the opposite argument that the judge used to side with you, is way fucking funnier than any amount of piss pants trying to muddy the waters about how valuable a precedent is and whether or not it's binding or persuasive, had between me and a series of other dipshits, foreign and otherwise, talking out of pocket about state law, state I don't even live in, right? Well, at least I live in the country enough to know that I fall underneath some of the same protections. But like, yeah, it was a very important decision. Okay, can you be disappointed that the h3h3 name is attached to it? 100%. But here's a more important thing. You can discount them if you want. You can discount their contributions to it, because aside from engaging with it at all, their case that they presented ultimately isn't what led to this. The judge had to help them and hold their hands to get to the end. And I think that's the important thing, is being more nuanced and doing your fucking research, and stop letting fucking lefties go off half-cocked at people only to stumble and fucking eat shit at the in the fucking end zone. I mean, you're like literally just doing the fucking Ethan Klein thing. You could have had a winner. Could have had a fucking winner in that post. Like, I don't even know if you know this, but when the Kleins, they say that they did this, but even the biggest parts of the decision that are for them, they were literally being corrected by the judge in the judge's own decision. You could have had that. Instead, you got made fun of. Why? Because you didn't do the research. You didn't sit down. You didn't think through things. You just let somebody feed you a talking point and then you regurgitated it. This is the biggest issue with people on the left right now. The fundamental issue is that you are piss pants mad at shit, and instead of fucking being an adult, calming down, and not letting yourself be led around by the fucking dick at everything that you're fucking mad about, you just do that. You just get fucking played. And it's easy to play people that are mad because they're mad. The easiest people to fuck with. You know, all the Republicans are all pissed off all the time, and they get tricked, and you're like, haha, you got tricked. Did you think it's different for you when you're mad? Did you think that your upsetty spaghetti hits different because you're morally perfect and pure? Did you think that they don't think the same thing when they're getting fucking tricked? You're people. You're human beings. But this is a major issue. Slow down, do your research, and double check and wait till you got something good to fucking hit somebody. You know, and then fucking hit the fuck out of them. Get them, but get them right, and get them so it sticks.
Hope you enjoyed your time on the West Side.